This year,
As opposed to
excuse me, this year it is absolutely uneventful compared to the last several years. So
hallelujah! Oh, praise the Lord!
So I'm just waiting for someone to, last time we were in St. Louis, time before last, we're sitting around in an executive board meeting, and Sam's process server walked into the room and handed us all a complaint. So maybe we'll still have something exciting like that before the week is out. Maybe all of you will be served too, since you're in the room with us here.
Well, they're all directors. No, a bunch of them are
Almost
directors.
everybody, I think almost everybody in here is a director.
Hopefully not for long, though.
No, you don't need that. We've got, Bill, three active suits. One is, I just made reference to, Sam Sloan served the board. Somehow he missed Alan, but
I wasn't on the board.
he meant to serve you.
I got sued, even though I wasn't on the board. I got sued for injunctive relief to put Sam on the ballot when I wasn't on the board with the ability to put Sam on the ballot. But, this was like the point.
I think
But
everybody.
you were never served.
But I never was served.
Everybody recalls that we had a controversy with one member who wanted to be on the ballot and did not conform to the delegates' guidelines for getting his name on the ballot, and he sued us in state court in Illinois, sued all of the individual executive board members, the executive director, and Alan, and the institution itself. That case has not concluded. The individual executive board members have been dismissed out. The real culprit is still in the lawsuit, and
Me and the USCF.
And
I do have a quick update to that from about an hour.
Wonderful, please.
July 31st, a motion was filed to dismiss for want of prosecution. So we should have a court date within the next 2 or 3 weeks to put this all completely behind us.
What does that really mean, dismiss for
Want
want of prosecution?
Want of prosecution is just a term that means that Sam's not doing anything with his lawsuit. The court's waiting for the plaintiff to take action, file motions to prosecute his civil case, and he's not doing it. So we filed a motion for want of prosecution, and my sense is that the judge wants to dispose of this case, but I will tell you that most judges are incredibly lenient toward pro se litigants. They give them every opportunity to go right or wrong in the prosecution of their case, so they're patient beyond belief with these guys, and Sam is getting all the benefit of being a pro se litigant, meaning he doesn't have a lawyer. That's all it means, and he'll be given every chance to make his case. If you've read any of his papers, which I think he posts freely on the forum, every time he files something with the court, he's very proud of his legal writings, and you can read them yourselves that there is just no merit to what he's suggesting whatsoever. Now, if any of the delegates have a problem with the way that the ballots were constituted for the election last year, we can certainly talk about that. Maybe this isn't the right forum for that, but we can certainly discuss whether we did anything right or wrong as an organization, as to how we selected the folks who went onto the ballot. But by and large, we have a fairly well-defined process. Our candidates adhere to it, and they land on the ballot if they do everything reasonably right. And it's not an overly complicated process. So any questions about what we styled as the Sam Sloan suit?
I would like to add, however, that this case has cost the USCF during the fiscal year ended running from June 1, 2011 to May 31, 2012, as stated on page 8 of your delegates call. It has cost us $10,861.50 in legal fees, and that case was not covered by insurance because the great state of New Jersey, in their infinite wisdom, added Mr. Sloan as a delegate last year which gave our insurer grounds to turn it down because it was a director of the corporation suing the corporation for a corporate issue. So the fact that Sam became a director last year certainly made it simpler for our insurer to turn the case down and cost the Federation at this point, and I'm sorry, not at this point, through May, almost $11,000, and certainly that bill will be higher than that by the time we get done, not appreciably, but it's going to cost us more to finalize the case. And if the judge grants leave and Mr. Sloan files additional motions, it will cost more for us to continue to respond to the case.
Alan, has this been brought to the attention of the New Jersey Federation?
Thank you, that was exactly what I was going to say.
I think
I doubt it.
We have not brought it to their attention
I suspect
yet,
we
but
should.
Yes. Sometimes our whims and fancies end up costing us a substantial chunk of change. Though I will say, in mitigating a little bit Alan's comments, is the fact that even had our insurer picked this up, we would have had a $10,000 deductible.
Right.
So we're on our dime, but we're certainly on the insurer's dime at this point if they had taken our case, which they did not do. So we're really down $1,000 that we wouldn't have been putting aside the insurance issue. But nevertheless, it's 11,000 real dollars that have been lost because of a, in my opinion, frivolous lawsuit. And I'm not bashful to say that one of the things that we're considering is seeking sanctions, and I'm not suggesting that we've looked into that very deeply yet, but it is something that we're considering. We would like to put brakes on future frivolous lawsuits, and judges will not typically issue sanctions without a motion from the prevailing party. So we have to consider that seriously. The downside, of course, is that such a motion would cost money, and even if such a motion prevailed, there is always the question of collectability. So we will go forward carefully. We're not vindictive, but we would like to stop spending $11,000 on such lawsuits. So any other questions on the Illinois state action involving our election process?
If the motion to make the delegates no longer the board of directors had been passed, and Sam had been a delegate, but the delegates weren't the board of directors, would the insurance company have then taken the suit?
That would have taken away that argument. Anyway, now,
yeah.
could they have found another argument? We don't know.
I'm not
That
sure.
would have taken away that
It
argument.
depends on whether or not the delegates would be covered by the insurance. I'm assuming that the answer is that they would not be, since they are no longer directors and it's D&O insurance, and therefore that would resolve that issue with the carrier.
But the suit would have been filed prior to the meeting last year, and so Sam was a delegate before the end of the meeting, not during.
Yeah, I'm really looking at this
And-
as in the abstract and prospectively. I agree with you. I don't think it would have affected this particular issue under the timeline that you're now discussing.
It is possible if we had passed it on Saturday, Sam didn't become a delegate until Sunday, maybe then might have escaped that.
The old neighbors unresolved.
Right.
Yeah, I was more interested in the long-term implications.
Yeah, prospectively, I agree with you, Tom. I think it is an issue that we would avoid in the future.
Also, technically, when the USCF is sued, actually, technically, you're all sued too,
Right.
as directors of the corporation.
Looks
So-
like about 800 each if you would just write a check before you go.
So it certainly would stop that part too, and the delegates wouldn't need the D&O insurance in that situation. But although the delegates would probably still be somewhat would still be covered, because we do cover, like, I think it covers committees.
Right, and that's why I raised some
So it's-
question as to whether or not people would be covered. I think there are some delegate actions that could fall underneath insurance coverage.
Right.
Ken?
It may not be appropriate for an open forum, I would understand that. I have a vested interest in this. What is the exposure of the elections committee?
The committee itself or its individual members?
Yes.
Its individual members. Realistically, negligible. I mean,
Well-
I'm really answering your question without a lot of facts and just kind of trying to overlay what's happened with the Illinois state action to what you all do.
Volunteer.
Gary, why don't, to answer it, it may be a way to answer his question to explain why the EV members were dismissed from the case.
Well, in essence, almost every state, and I believe federal law too, has an act or a statute which provides tremendous protection against volunteers to charitable organizations.
Who act in good faith.
Yes, who act in good faith. And you're usually even excused from basic negligence. Usually it has to be something egregious, such as malice, or, Harold, help me, what's the next level of negligence?
Willful and wanton.
Yeah,
Gross.
perhaps.
Gross.
Gross negligence, perhaps, is the way many states put it. Unless you're violated of one of those, very high standards, you're protected by these statutes, which virtually every state has. Illinois does, and that's the one that's caught and protected the executive board members in this case. He just couldn't make a case that there was any, malicious activity going on toward him. I may have had some in my mind, but I didn't
You
act on
can't
it
yet
in any
convict a
way.
man for what he's thinking.
Yes, that's right.
Actually.
Unless you say it out.
You have heard of conspiracy?
Any
That
other,
requires an verdict.
any other questions or comments on the Illinois state action? The second piece, and Bill may know more about this than I, is we still have a remnant of the Polgar lawsuits with Alexander. And we have been working with our counsel for quite some time. Well, the civil case has been stayed while the criminal case has gone forward against Alexander, and he has pled out, almost done on the criminal side.
What was the pleading?
And he's taken a guilty plea. I don't know exactly on which charges he took a guilty plea.
It was one charge, but it was not, it didn't have any jail time with it. It was a year probation. Goes on his record, obviously.
This was a
it
wiretap
mis-
charge,
It
right?
was a misdemeanor, it was a misdemeanor level. What was the official charge?
I don't recall. I don't
exactly
recall.
how it was worded, but,
Interception.
and also there's, it's not, the criminal is not completely resolved because it's waiting, the court is actually waiting for our negotiations with him to finalize to put aside the civil suit, which is kind of odd that this occurred this way, because usually they want to completely divorce the two, but because they haven't made a ruling yet on restitution.
So we're trying to wrap up. I don't know how others feel, but I'm going to tell you how I think the organization feels, and certainly how I feel. I'd like to get this done and get it behind us, and be done with all of these lawsuits that are associated with any of that activity that we all know so well. And we're simply trying to do this right, make sure that the organization gets all the protection that it can for any events that might surface in the future. It includes a statement, we helped craft the statement that Alexander read into the court records. Unfortunately, we don't have that statement with us. I've seen it
It's
before.
on the way, it's in the forums.
Yeah, it's in the forums. It's a strong, very protective statement. It implicates others than Alexander in the activities that occurred. And it is now a court record. It's an admission, a sworn statement made by Alexander in court that relates to some of the activities and who encouraged him to do what, when. That piece is done and set aside. Now, what remains is hard drives that were in his possession, and we are trying to secure our ability to see what's in those hard drives. And we're going, and that's where the negotiations are occurring. He's resistant to simply turning over those hard drives to us and putting them into our possession, but there's a lot of information on there, a lot of information that was gleaned from those hard drives by the prosecutors, and we're trying to secure any information in there that's protective of our rights and our positions, whatever may come up in the future. And that's where the negotiations are at present, just how we're going to get that information, how much of it we're going to get, in what form we're going to receive it.
We would receive it anyway through the civil case. It's just, we're not going to settle the civil case until we have them.
In whose physical possession are those hard drives?
Government.
Okay.
These are the hard drives that were dug up out of his backyard?
Yes.
Yeah.
What?
For the record, there were 2 hard drives buried in his backyard and one hidden in another location. That when they seized his computer, they did not find those, and he, as part of his proffer for staying out of jail, he offered them up
Well, then, you know,
with other information.
there's probably nothing incriminating on them, because that's where I keep my hard drives.
Yeah.
So in any event, that's what's going on there. We're trying to bring that to closure in a humane and compassionate way, be done with the case, but at the same time, not give away anything that rightfully ought to fall into our hands and belong to us to help protect ourselves. As far as I'm concerned, I would like to get the information and put it on the highest shelf in the darkest room at USCF headquarters and leave it there forever, but would like to control it for whatever reason, should we ever need it again.
If at this point the civil case is settled, is it possible that a quiet judgment might be sought against third parties in which is $500,000 is repaid at a couple $1,000 a year or something like that, just symbolically to hold this over or more than symbolically, you know, like people do die eventually, and why not collect from their estate?
Well, $500,000 is pretty symbolic.
Yeah.
That's a lot of symbolism.
I'll take it.
Well, you can make a symbolic donation to the USCF.
Well, if you know, we're all being just a touch cryptic here, but if I'm understanding you, I think that most of what you're suggesting right now would be covered by settlement agreements that have already been entered into.
Yeah, but the settlement agreements didn't assume potential criminal conduct by third parties, did they? It's like if one subsequently learned that there was criminal conduct by third
I would
parties.
have to read the settlement agreements again, but settlement
Okay,
agreements
so
are
you-
generally crafted to be very broad.
Okay.
And yes, any and all claims that may or may not, you know,
So-
it's just very broad
So
language to
that
present
ain't
to prevent just this sort of thing.
Okay.
So we'll have to give that another look.
I think that it was also from the beginning of time until this point.
Yeah, it's. I
It
did not-
washed everything clean.
I wasn't on board at the time. I didn't have a hand in the settlement agreement, but I know how every settlement agreement I've ever written or been a part of has been written. They're designed to cut off this kind of future activity.
Parties who were not subject to the settlement agreement could take whatever action they wanted to.
Yeah. I mean, settlement agreements are contracts. Think of them as contracts. And most of the times, you can even think of them as extrajudicial. They are just contracts that sit on the side, typically with the court maintaining jurisdiction over enforcement of the contract. But they're contracts between the parties.
With whom do we have settlement agreements in this matter?
With our opposition in the Polgar lawsuits.
Okay, all parties.
To my knowledge, everybody was a party to the settlement agreement. Everybody who was a party to the litigation was a party to the settlement agreement. That's how those, with Alexander being an exception, but that's how those things get settled. They typically get settled globally, or they're of little use.
There is an exception. I think Mr. Sutton was not a party to the settlement agreement, and, you know, whatever case Mr. Alexander might make possibly against parties, it would be up to Mr. Alexander. I mean, just in all fairness, I mean, that, you could envision going down that path, but
Anybody-
the USCF would not be part of it.
Anybody who's not a signatory to it is not bound by it, for sure. It's a contract. Think of it as a civil contract, just like you would make for having somebody work on your house. Any other questions about the Alexander case? Then the last piece, some of you probably already heard of in the executive board meeting earlier today, is the FIDE piece. There is a remnant there where FIDE has gone back they went back to the Swiss court to try to get a review of the sports arbitrators' decision for what FIDE regarded as a very low compensation for what it saw as a victory. They recuperated a very small percentage of their legal fees and costs as a result of the arbitration, and they wanted more. They went into Swiss court. The Swiss court said, no, we're not going to do this. And I'll just tell you, as a matter of policy, that courts everywhere are very protective of arbitrators' decisions. It's what keeps the whole arbitration system afloat. If courts were very quick to overturn arbitrators, then arbitrations would become much less valuable. All of those cases would flow into the courts and clog up the courts' dockets. So in this country, for example, a court has to find that an arbitrator's decision is arbitrary and capricious before it will overturn it. If I'm an arbitrator, I can actually get the law wrong, and the courts will still uphold my decision unless they can find that I was arbitrary or capricious, malicious almost in the way that I went about making my decision. If I'm just making ordinary mistakes, the courts will uphold me. Other foreign courts, especially Western courts like Switzerland, are not very much different than our own, and they would not hear the case. But they did say that there appeared to be a procedural flaw in the arbitrator's decision, and that FIDE did not have a full opportunity to be heard, and so they sent it back to the arbitrators for review. And that's where it's been for quite some time. And if you can, you have to imagine that our chances are good in that process, because the same folks who made the decision are going to review the decision, their own decision, as to how they awarded compensation at the end of the arbitration. There was some concern raised earlier in the executive board open session. What's our exposure? Our exposure remains the same as it's always been, and I'll simply repeat that. Our legal fees are being absorbed by White & Case, one of the premier law firms in the United States. They have in writing assured us repeatedly that they will represent us to the end of this legal action, and they have done so, and they will do so without charge to us. So the really expensive side, the legal fee side, is covered by White & Case. If we have liability, sir?
Do we know who their client is?
Do we know who their client is? Their
Yeah.
client in this case is us.
Us,
Who's paying the
four
bills?
other.
It's pro bono.
It's pro bono. Right.
People
Okay, the Karpoff
can't,
camp.
if there's any judgment against them.
Okay.
But the legal representative's representation has been pro bono.
Yeah.
Okay.
Now, with respect to liability, which is another matter, you got the legal fees, half of it, and liability, any liability that comes out, White & Case would certainly not pay if we were found to be owing money. That's not what they do. Law firms don't agree to do that. The Karpoff campaign, though, has agreed to pay every dime. And I believe, in fact, they said they put it in such a way that even if there were stamps to be put on envelopes, they would pay for the stamps to be put on the envelopes.
And they have.
And we have no reason to disbelieve that they'll do that. We think our exposure is zero. Those are famous last words.
Now, part of what will come up in the international meeting that starts after this one in another room is FIDE and Annex 60 for the Congress coming up. Mr. Ali Yazizi, I believe is how you say his name, from Turkey, has put forward a proposal to ban all federations that were related to any class actions against FIDE until FIDE has been restored all of its legal fees.
Well, we could join the North American Chess Association.
Yeah, you're funny, Bill.
So that will be an interesting topic for the international meeting.
Any questions on the remnants then of the sports arbitration? That's what's currently active to my knowledge. There's nothing else out there at the moment. It's all, you know, all legal actions are concerned, but relative to what we've been experiencing in the past few years, it seems very minor at this point.
We haven't even been threatened to be sued lately.
Can
That's
I-
unusual.
But Sam's not here yet.
Can I bring out?
Just saying.
I think this is the appropriate forum just to mention one other thing, and it's on page 8 of your delegates call, where it lists the legal expenditures, and it shows governance and miscellaneous, $3,300. A lot of that's me, and what I mean by that is as we worked through the bylaws stuff from last year's board meeting, rather than just guess at how Illinois would apply, how Illinois law would apply, we actually consulted our attorney in Illinois to make sure that in adopting and executing what the delegates directed from last year to bring back to this year, that we had it right. So there's some more related to that because I was working with the attorney as late as yesterday, but not a lot more. I mean, there's another 4 or 5 hours that aren't included on here, but that's what those charges are about. And it was to make sure that we don't have unintended consequences of making changes later or making changes that turn out to be not legal under Illinois nonprofit law. So that's what we incurred those fees for.
So basically, you cost us a third of a slum.
I did. Trying to prevent a bigger one later.
Money well
That was
spent.
preventative maintenance.
I'm curious about the consequences of that motion before the FIDE Congress. If it passes, would American players be banned from FIDE events?
That would ban everything in existence, essentially.
Interesting.
No ratings,
No events, no
American
players.
no FIDE arbiters, just international arbiters.
Interesting.
Everything. Of course, another interesting thing there, the proposal was made by a guy who sued the European Chess Union as Turkey and lost and and the judgment was he had to restore all of their legal fees. The case was so bad. And because we sued FIDE, he says we ought to be excluded from FIDE.
And the countries in that case were the U.S. and
U.S.,
Switzerland, France,
Germany, France,
Ukraine.
Ukraine. And then afterwards, there was another case brought by England and Georgia over another topic.
And they've been mentioned in the same breath. So perhaps we'll be having our own world championship next year.
Our own Olympiad.
Yeah. So look, we're always walking a tightrope on legal risks and legal expenses. We do try to proceed very carefully. Alan tries to make sure that the Illinois Council is looking at all of our bylaws decisions. I'm on the phone constantly with Bill with respect to ethics complaints and any kind of sanction or limitation of our players' rights to participate in chess. We constantly are talking through those things. We attempt to go forward carefully and to foreclose as much legal action as we possibly can, but there's always some risk when you're talking about a national organization.
International,
I don't know.
Yeah, I think it is.
Internationalism here.
okay. Yeah, come on now.
Any other questions on legal?
I don't know, well, here, this one could be.
All right, thank you very much. I guess international's in this room starting in about 15?
20 minutes. Yeah, 20 minutes.